In the county courthouse of Troopville, Lowndes County, Georgia, a civil hearing scheduled to last a single morning in October of 1859 stretched instead into 3 days of testimony that would later be cited, though never fully resolved, in at least 2 subsequent property disputes filed within the same county. The matter on the docket concerned the estate of a deceased planter, Silas Bellamy, and the division of roughly 420 acres of farmland between his 2 surviving children, Edward Bellamy and Margaret Bellamy, both of them adults at the time of the proceeding. According to the surviving clerk's docket, preserved on microfilm after a courthouse renovation in the town in 1963, the hearing began without incident. Witnesses were called to confirm boundary lines, harvest yields, and the authenticity of a deed. Then, on the second morning, Edward Bellamy rose from his chair, turned toward the rear benches where the household witnesses sat apart from the family, and addressed a woman named Ruth Elkins as mother. The court record notes only that a disturbance among the gallery required the sheriff's attention, and that the presiding judge, Thomas Calloway, called a recess of nearly 40 minutes. A brief note appended by the clerk to the margin of the docket, overlooked in earlier transcriptions of the case and recovered only when the university historian examined the original page under magnification in 1965. Adds a detail, absent from the formal record, that several persons present left the room entirely and did not return before the recess ended, a line the historian's article treats as evidence that the moment's disruption extended beyond mere noise or commotion into something closer to a shared and immediate recognition, among at least some of those present, of exactly what the word implied and what it would mean for the case and for the family going forward. No transcript survives of what was said in that recess. What survives instead is the testimony that followed. Fragments of correspondence recovered decades later, and the account of a Bellamy family ledger that a graduate researcher from Atlanta would find, water-stained and partially illegible, inside a trunk sold at an estate auction in the town in the autumn of 1964. Before any of that, however, there was simply a household, and a routine so ordinary that none of the people living inside it, according to every account later gathered, believed for a moment that it concealed anything at all. The Bellamy farm ran on the rhythms common to properties of its size in that part of southern Georgia. Planting in early spring, the long stretch of chopping and hoeing through summer, the harvest beginning in September and running, some years, well into November depending on rain. Silas Bellamy kept to a fixed schedule, rising before dawn, riding the fields with an overseer named Jacob Pruitt, whose own descendants would later be interviewed for the 1961 folklore project, and returning to the house each evening at an hour precise enough that Pruitt's own account described it as regular as the church bell and about as warm. Caroline Bellamy in these same years was seen at church perhaps 4 or 5 times annually, always seated apart from the rest of the congregation in a pew near the rear, always departing before the closing hymn concluded. The Baptist Church's own membership roll, a portion of which survives in a regional archive, lists her attendance as irregular, owing to delicate health, a phrase copied word for word from the language Silas Bellamy himself used whenever the subject arose among neighbors, a repetition that struck at least one local minister, according to a letter he wrote to a colleague in 1851, as curious in its uniformity, as though rehearsed. It was within this outward stillness that Ruth Elkins moved through her days, managing the kitchen, overseeing what few other domestic servants the household kept, and caring for the 2 children, Edward and later Margaret, from their earliest infancy. Household inventories from the period list a cradle, a rocking chair, and later a set of children's furniture, all itemized under the general household account, rather than any account attributed to Caroline directly, a detail the university historian's later research treats as circumstantial but suggestive. Neighbors who visited rarely saw Caroline with the children at all. One visiting relative, a cousin of Silas's from Thomasville, wrote in a letter dated 1842 and later recovered among family papers that she had called at the house expecting to see the new baby in his mother's arms, and had instead found him quite contentedly with the woman Ruth, who seemed to know his every want before he could speak it, while Cousin Caroline kept to her room, as is now her custom. The letter continues, almost as an aside, that the writer thought it odd, though of course said nothing. A phrase that recurs, in one form or another, across nearly every piece of correspondence historians have recovered concerning the Bellamy household in those years. Odd, but unspoken. Noticed, but never named. Ruth Elkins was, by every official document available before that October morning, a woman without a surname that mattered to anyone but herself. The county tax rolls of 1859 list her only as property, valued alongside 2 mules and a quantity of stored cotton under the Bellamy household. She had served in that household, according to her own later testimony, for 20 years, arriving as a young woman not long after Silas Bellamy's marriage to a woman named Caroline Ashworth. She was, by that point, in her early 40s, though the exact year of her birth was never recorded anywhere the court could locate. She walked into the courthouse that October with a composure that several witnesses would later describe, not as calm, but as the particular stillness of someone who had spent 2 decades learning to say nothing in front of people who could punish her for speaking. She was called at first as a minor witness. The clerk's docket lists her only under the heading Household Testimony, beneath 3 other names, all of them white employees of the Bellamy estate hired to manage livestock and fieldwork. Nobody in that courtroom on the first day expected her word to matter. The Bellamy farm sat some 6 miles outside the town, along a stretch of sandy road that ran parallel to a slow creek locals called Miller's Branch. Though no Miller had lived in the county in living memory, the house itself, according to a surviving 1852 insurance assessment recovered from a Savannah archive, was a 2-story frame structure with 4 chimneys, unusually large for the size of the landholding, a detail the assessor noted without further comment. Neighbors interviewed decades later by a folklore collector working for a state university project recalled the property as quiet in a way that made people talk. One woman, identified in the collector's 1961 notes only as Mrs. H., granddaughter of a Bellamy tenant farmer, described the house as a place where you didn't linger past sundown, not because anyone told you not to, but because nobody ever asked you to stay. The Bellamy family, in the years before the hearing, was regarded locally as prosperous but withdrawn. Silas Bellamy sat on the vestry board of the county's Baptist congregation and was listed as a subscriber to 2 regional newspapers, the Savannah Republican and a smaller Thomasville weekly, but he rarely attended town functions, and his wife, Caroline, was seen so infrequently outside the property that a county physician's billing ledger, recovered from a descendant's attic in 1962, records 7 separate consultations of a private nature over a span of 11 years, with no further description of her condition. Silas Bellamy's final illness, according to Dr. Kittredge's billing ledger, began in earnest in the late spring of 1859 and progressed over roughly 5 months, a decline the ledger records through a series of increasingly frequent visits, the last dated some 11 days before his death in September. It was during this final stretch, according to Edward's own later testimony, that his father began speaking in a manner Edward described to the court as unlike anything he had heard from him before. Fragments of sentences left unfinished, references to people Edward did not recognize, and at least twice, according to Edward's account, an instruction to fetch Ruth to his bedside so that he might speak with her alone, instructions Margaret disputed ever having occurred, though the household's remaining domestic staff, when questioned briefly on the matter, offered testimony neither confirming nor denying it with any confidence, citing only the general disorder of a sick room in its final weeks. Edward returned to the property from Savannah in early August, summoned by a letter from Margaret informing him of their father's declining condition, and it was during the 6 weeks between his return and Silas Bellamy's death that Edward stated he first began to suspect that the story of his own birth, told to him the same way for the whole of his life, might not survive close examination. He testified that he found his father on one occasion in early September, sitting up in bed and speaking, in a voice Edward described as unusually lucid for that stage of his illness, about a woman he called only the ward girl, and about a promise he said had gone unkept, though he did not, in that conversation, specify what the promise had been or to whom it had truly been owed. Edward testified that he had pressed his father further the following week, and that Silas had told him only, "Ask Ruth what she carried on her back for this family, and you will have your answer, though I hope to God you never need to ask it in a courtroom," a statement Edward said he did not understand until the writing desk was opened months later, and one for which no independent corroboration survives beyond Edward's own account, offered under oath and never directly contradicted by any other witness. It was this exchange, more than any single document, that appears to have prompted Edward's decision, arrived at some time in the weeks following his father's death and before the property hearing began, to treat the coming dispute over the estate not merely as a matter of acreage, but as an occasion to finally ask, in the one setting where his sister and her attorney could not simply dismiss him with silence, the question the household had spent 2 decades teaching everyone within it never to ask aloud. The family history, compiled later by Ruth Elkins's own descendants, preserves a fragment of oral tradition on this point, attributing to Ruth herself in an account passed down through at least 2 generations before it was ever written down, the recollection that Edward had come to her privately in the days before the hearing and asked her directly whether the story of his birth was true. According to this tradition, Ruth did not answer him with words at all, but simply looked at him for what the family account describes as a long moment, long enough that he later said he understood the answer before she ever opened her mouth. And it was only then, according to the same account, that Edward told her he intended to acknowledge her before the whole court, whatever it might cost either of them. Ruth is said to have replied only, "It will cost you less than it has already cost me," a line the historian's article treats with appropriate caution as family oral tradition rather than documented testimony, but one it nonetheless includes, noting that even where verification is impossible, some accounts carry the unmistakable texture of lived memory rather than invention, and this researcher was reluctant to omit it entirely. It was into this household that Ruth Elkins had been brought, and it was within its walls that both Bellamy children Edward and Margaret had been raised from infancy, cared for, according to every account gathered after the fact, not by their mother, but by her. The official narrative, repeated by the family for 2 decades and confirmed by no fewer than 4 hired household staff in earlier depositions unrelated to the 1859 case, held that both children had been born during periods when Caroline Bellamy was in seclusion at the family home, recovering from what was described only as delicacy of constitution. Silas Bellamy, according to Ruth's later testimony, had been explicit with every servant in the house. The story of the children's birth was to be told the same way every time, to every visitor, every relative, every minister who asked. Ruth said, when pressed by Margaret's attorney on the 2nd day of the hearing, that she had repeated that story so many times over so many years that she had, in her own words, as recorded in the surviving partial transcript, near enough believed it myself some mornings. The attorney asked her to clarify what she meant. She did not. The occasion that set the hearing beyond the boundaries of a routine property dispute was not strictly Edward's outburst. It was what followed it, a request made by Edward's own attorney over Margaret's objection that the court examine a locked writing desk that had belonged to Silas Bellamy, kept since his death some 5 months earlier in the estate's front parlour, a piece of furniture the family had not previously disclosed as containing anything relevant to the dispute. Margaret's attorney, a Savannah-trained lawyer named Whitfield, argued that the desk was private family property and irrelevant to a matter of land division. Judge Calloway, according to the surviving docket notes, allowed the request in the interest of a full accounting, in a phrase that would later be quoted at length in a 1966 Regional History Journal article examining what its author called one of the few documented instances in antebellum Georgia court records where a testimony of an enslaved witness altered the outcome of a civil estate matter. That article, written by a university historian and based on the recovered ledger and transcript fragments, forms much of what survives concerning the case's later chapters. Before the desk was opened, however, the court spent the better part of a full day working through the ordinary business of the dispute. The deed Margaret's side presented, a letter allegedly signed by Silas some 4 months before his death, granting her the greater share of the estate on account of her having remained, in the letter's language, dutiful and present, while Edward had spent several years working as a factors agent in Savannah and, according to a family letter recovered later, had been largely absent from the property during his father's final illness. Edward's side did not dispute that his father had written such a letter. What Edward disputed was that it represented his father's final intention. He told the court, in testimony corroborated years later by a partial letter found among Ruth Elkins's own possessions, passed down through her descendants and eventually donated to a historical society archive in 1967, that his father had confided to him in the final weeks of his illness that there existed another paper, one that told the truth of things, and one Margaret must never find. Edward could not, at the time of the hearing, produce this paper. He could only assert its existence and ask the court to compel a search of the household's private effects, including the writing desk. The historian, whose work preserves most of what is known about the case today, did not begin her research with the courthouse docket at all. According to her own account, published as a preface to the 1966 journal article, she first learned of the matter from a passing reference in a regional genealogy newsletter in the spring of 1963, a single sentence noting that a curious testimony once altered a Lowndes County inheritance case before the war involving a household servant. Intrigued, she traveled from Atlanta to the area that had once been Troopville, by then reduced to little more than a crossroads and a small cemetery. The town's civic functions having relocated entirely to Valdosta more than a century before, she wrote that she found no marker, no plaque, nothing at all to indicate that a courthouse had once stood there, only a historical society volunteer in Valdosta who recalled, vaguely, that some old Bellamy papers had once been donated, sold, or simply left behind by a descendant clearing out a family property some years earlier. It took her the better part of a year, working through estate sale records and a chain of increasingly distant relatives, to locate the trunk itself, which by the autumn of 1964 had passed into the hands of a widow in Thomasville who had inherited it from an aunt and had, by her own admission, never opened it, believing it to contain nothing but old dishes. The historian's notes describe opening the trunk in the widow's front parlour under poor light and finding, beneath a top layer of cloth and broken crockery that seemed to confirm the widow's assumption, a false bottom concealing a bundle of papers wrapped in oilcloth that had, remarkably, kept out most of the damp. Among these papers were the fragments of the 1859 court transcript, several personal letters, the family Bible with its added marginal note, and what the historian's notes describe as a smaller, separate packet tied with string gone brittle with age, containing what appears to be Ruth Elkins's own correspondence, kept evidently by her own descendants for a time, before somehow finding its way back into Bellamy family hands, a circumstance this researcher has not been able to fully account for and does not wish to speculate upon without further evidence. The site of the house itself, when the historian visited it in the winter of 1964, offered little. The 1969 survey conducted ahead of the road widening project would later confirm what she had already observed. A shallow depression in the ground where a cellar had once been, a scattering of brick from a collapsed chimney, and a stand of overgrown crepe myrtle that a local farmer told her had been planted by the ladies of the house generations back, and nobody's had the heart to clear it since, though nobody visits it either. She wrote that she stood at the edge of that depression for some time, and that she found herself unable, in her published account, to describe what she felt beyond a single sentence she allowed herself in an otherwise clinical preface. There is a particular quiet to a place where a great deal was once said in whispers, and none of it in the open air, and I do not think that quiet ever entirely leaves such a place, however long it has stood empty. Ruth Elkins's testimony on the matter of the household's routines occupied most of the second day of the hearing itself. Nearly a century before that visit, she was asked about the placement of keys, about who had access to Silas Bellamy's private office, about which visitors arrived at unusual hours, and about a set of correspondence she recalled being burned in the library fireplace on several occasions over the years, always by Silas Bellamy's own hand, always late in the evening. She testified that she remembered a ledger, kept separately from the estate's public accounts, with several pages torn from its binding sometime around the year of Margaret's birth. She testified that she remembered a document which she described only as a paper with a church seal, kept for a time inside the family Bible, a large volume that sat on a shelf in the upstairs hallway and was rarely opened except for recording births and deaths on its end papers. In keeping with a custom common to the region, she testified, when asked directly by Whitfield whether she had ever travelled with Silas Bellamy to the city of Savannah, that she had on one occasion, some 21 years prior, though she had not been told the purpose of the journey, and had waited 3 days in a boarding house, while Silas conducted what he described to her only as business. She testified finally that she remembered a woman named Eliza Ward, a free woman of some means, who had, for a period of roughly 2 years, been a frequent visitor to the Bellamy property, and who had then stopped visiting entirely, and whose name Ruth said she had not heard spoken aloud in the household again for nearly 20 years, until the week of the hearing itself. Before the hearing had even reached the matter of the writing desk, the name Eliza Ward had already surfaced once, briefly, on the first day, in testimony from one of the household's field hands, an elderly man named Amos, listed in the docket only by his first name in the manner typical of the period's court records. Amos testified that he recalled, as a much younger man, a woman of that name visiting the property of an evening, and never through the front road, always the back path by the creek, in a detail Whitfield attempted to strike from the record as irrelevant to the estate matter at hand. Judge Calloway allowed it to stand, according to the docket notes, for context only, a ruling the university historian's later article suggests was likely a courtesy the judge himself did not yet realize would prove significant. Amos further testified that the visits had stopped abruptly one autumn, and that in the weeks following, he had overheard Silas Bellamy instruct the overseer, Jacob Pruitt, that no one on this place is to speak that woman's name again, to family or to God. An instruction Amos said had been obeyed without exception for nearly 2 decades, until the week of the hearing broke it. What became of Eliza Ward after that autumn is a question the surviving record answers only through absence. The 1966 Journal article, drawing on the county's tax rolls, deed books and church membership records, traces her presence up through the year 1838 and finds no trace of her afterward. No sale of property, no marriage record, no burial listing in any of the county's 3-period cemeteries, whose surviving stones were catalogued by a preservation society in 1959. A single church record, a note appended to the Baptist congregation's membership book in an unidentified hand sometime around 1840, reads only, E. Ward, removed. A phrase the article's author notes was used elsewhere in the same book to describe members who had relocated to other counties, but which appears nowhere else applied to a member for whom no forwarding church or town is recorded, an omission the author calls, cautiously, unusual, though the record itself offers no further explanation, and speculation beyond what the documents support would not serve the historical account. Local oral tradition, gathered by the same 1961 folklore project that interviewed Mrs. H., preserves a fragment attributed to an anonymous elderly informant, who is recorded only as saying that the old people used to say a woman went into that county and never came out of it the same, if she came out of it at all, a statement the folklore collector's own notes describe as unverifiable and possibly conflated with other local disappearance stories common to the region, a caution the collector was careful to record alongside the informant's words, and one this account preserves for the same reason. It is at this point in the surviving record that the documentary trail becomes fragmented in a way that historians examining the case have found frustrating, but not, given the period, unusual. County records show that a woman named Eliza Ward is listed in an 1838 tax roll as owning a small parcel of land near the town, along with what the roll describes only as sundry goods. By the 1840 tax roll, her name does not appear. No death record survives. No sale of her land to another party is recorded in the county's deed book for that decade, an absence the 1966 Journal article's author calls conspicuous, though not, on its own, evidence of anything beyond the ordinary carelessness of period record-keeping. A single letter, undated, unsigned, and addressed to no one by name, was found among the papers eventually recovered from the writing desk. It reads, according to the transcript excerpt quoted in the later historical account, as an appeal from a woman asking to be permitted to see the children, and stating that she had been promised a settlement of some kind that had not, as of the letter's writing, arrived. The historian's article notes that handwriting analysis conducted informally by a state archivist in 1968 suggested, though did not conclusively establish, that the letter's hand matched a signature on the 1838 tax roll belonging to Eliza Ward. Margaret Bellamy's response to Ruth's testimony, recorded second-hand through Whitfield's cross-examination rather than any direct statement of her own, was to characterize the household routines Ruth described as unremarkable, and to suggest that a woman who had spent 20 years as a servant in a family's employ might naturally come to imagine a closeness to that family which did not, in fact, exist. Whitfield asked Ruth, according to the partial transcript, whether it was not true that many household servants grew attached to the children they cared for, and whether such attachment might not, over time, come to feel to the servant like something more than what it truly was. Ruth's answer is recorded only in part. The surviving fragment reads, "I know what I raised, I know what I fed and washed and sat up with through fever. Whether the law has a word for that, I could not say. I only know the word the boy used yesterday morning, and I did not teach it to him." Margaret herself did not take the stand that day, nor at any point during the 3-day hearing. a fact the university historian's article notes as consistent with the period's customary reluctance to place a woman of her social standing under direct examination in a matter touching on family scandal, but one that also leaves her own perspective almost entirely absent from the surviving record, save for a single letter written some weeks after the ruling to an aunt in Charleston, portions of which survive in a private collection consulted by the historian. In it, Margaret writes that she does not dispute what Ruth Elkins did for her and her brother as children, and that she remembers with what the letter calls an affection I have never permitted myself to examine too closely, being cared for through a childhood illness by a woman whose hands she says she can still picture more clearly than her own mother's. She writes, however, that she cannot forgive what she calls the manner of its revealing, by which she appears to mean not the truth itself, but the public setting in which it was forced into the open, stripping her, in her words, of the only inheritance that mattered more to me than the land, which was the name my father's name had always been permitted to carry unquestioned. The letter closes without resolution, and the historian's article observes only that Margaret Bellamy appears in no further Georgia records after her relocation to South Carolina, her later life, by all evidence, deliberately obscure. Caroline Bellamy, for her part, left behind almost nothing in her own voice beyond the single marginal note discovered years later in the family Bible, a silence the surviving record treats as consistent with a woman kept by her husband's own design, apart from the household's daily life for the better part of 2 decades. A single fragment, however, survives among the papers recovered from the trunk, 3 pages, undated, torn from what appears to have been a larger notebook, written in a hand the historian's research identifies, through comparison with other confirmed samples of Caroline's writing preserved in a family correspondence collection, as almost certainly her own. The pages do not read as a diary in any sustained sense. They are disconnected, several lines crossed out, and at least one passage rendered illegible by water damage. What remains legible includes a line reading, "R sat with the boy the whole night through, and I did not go in, for I did not know what I would say to him, or to her, or to myself." And another, written in a noticeably different, more hurried hand, as though added later, and that reads only, "It was never asked of me whether I wanted this arrangement. It was arranged, and I was told to be grateful for the appearance of a family, if not the substance of one." The historian's article treats these fragments with caution, noting that they cannot be dated with certainty and may reflect a single period of distress rather than a settled state of mind sustained across Caroline's entire adult life, but concludes, carefully, that if genuine, and there is little reason based on the handwriting evidence to doubt that they are, these pages suggest a woman who understood a great deal more of her own household's central deception than her public seclusion allowed her at the time to say aloud to anyone at all. The examination of Silas Bellamy's writing desk took place on the morning of the 3rd and final day of the hearing, in the presence of Judge Calloway. Both attorneys, Edward, Margaret, and, at Edward's specific request over Whitfield's renewed objection, Ruth Elkins. The desk itself, described in a probate inventory filed shortly after Silas's death as one mahogany writing desk locked, contents unknown, had sat unopened for 5 months, its key reportedly lost. A locksmith summoned from the town forced the lock rather than damaging the desk's surface. The docket notes record that the process took the better part of an hour, the locksmith working with a set of picks, while the room waited in what Judge Calloway's own brief marginal comment on the docket describes only as considerable and uncomfortable silence, a phrase unusual enough in an otherwise dry legal record that the historian's article quotes it directly as evidence of the tension the room held that morning. When the lock finally gave, the desk's upper compartments produced nothing beyond the estate's ordinary correspondence, several unpaid invoices from a Savannah merchant, and a small tin box of coins that Whitfield, according to the docket, attempted to have set aside as immaterial before Judge Calloway ordered the examination to continue. It was Edward who is recorded as having asked, at that point, that the desk be checked for a false bottom, stating that he recalled his father mentioning, during the final week of his illness, in a moment Edward described as more delirium than conversation, a phrase resembling beneath where the coins sit. The locksmith found the mechanism within several minutes. A thin panel, sprung by a catch disguised as an ordinary screw head, concealing a shallow drawer no more than 2 inches in depth. Inside, according to the docket notes and later corroborated by items eventually catalogued by the Historical Society that received portions of the Bellamy family papers in the 1960s, were 3 separate items: an unfinished letter addressed to no recipient and breaking off mid-sentence, a baptismal certificate, its date and one name visibly altered with a different ink. The alteration crude enough that Judge Calloway is recorded as remarking it was plain to any eye once shown, and a signed statement dated some 11 days before Silas Bellamy's death, in his own hand, and witnessed by the family physician, a Dr. Ambrose Kittredge, whose own billing ledger, recovered separately decades later from a descendants' collection, corroborates a visit to the Bellamy property on that precise date, listed simply as consultation and witness to a private paper per Mr. Bellamy's request. The statement, portions of which are quoted in the 1966 journal article and which the article's author states were transcribed directly from the original document before it was donated to the Historical Society, did not read as an act of gratitude, and several who have examined it since have noted this as one of its more unsettling qualities. Silas Bellamy did not write that Ruth Elkins had raised his children out of love, though he acknowledged that she had, in practice, raised them. He wrote instead that she had done so because he had required it of her, and that her presence in the household, her care of the children, and her silence regarding the circumstances of their birth had together served a purpose he described plainly as protecting the good name of this family from a truth that would have ended it. He wrote that Caroline Bellamy had known the truth and had chosen, for reasons the statement does not explain, to live within the fiction rather than expose it. He wrote that Eliza Ward had been paid for a time to remain silent, and that when she had ceased to accept the arrangement and had instead demanded to be acknowledged, he had ensured, in language the statement leaves deliberately vague, that she would trouble the family no further. The statement does not specify what became of her. The historian's article examining county records from the following decade notes only that no further trace of a woman by that name appears anywhere in Lowndes County after the year 1840, and states that the question of her fate remains, as of this writing, unresolved, and likely permanently so. The statement closed, according to the quoted transcript, with a sentence that the journal article's author describes as the document's coldest line and its most revealing. Silas Bellamy wrote that he called Ruth Elkins mother to no one, and permitted no one else in his household to do so either, not because the word was untrue, but because he understood, better than anyone, exactly how true it was, and exactly what its acknowledgement would cost him. He wrote that he left this statement not as confession, but as record, so that should the truth ever surface after his death, it would not surface as rumor, but as something that could be verified. Whether this was an act of conscience or merely a planter's habit of keeping meticulous accounts, even of his own failures, is a question the surviving record does not answer, and one the journal article declines to speculate on, beyond noting that the distinction may not have mattered a great deal to the woman the statement was at last about. Judge Calloway's ruling, delivered the following week and preserved in a summary form within the county's civil docket book, did not grant Ruth Elkins any personal claim to the estate, a possibility her testimony had never in fact sought, and one the law of the state at that time would not in any case have recognized. The ruling instead addressed the dispute as originally framed. It invalidated the letter Margaret's side had presented as evidence of Silas Bellamy's final wishes, citing the discovery of the altered baptismal certificate as sufficient cause to question the reliability of other undated or unwitnessed documents attributed to the deceased, and it ordered a more equal division of the estate's land between Edward and Margaret than either had originally sought. A resolution the journal article's author calls a legal compromise that satisfied the technical demands of the case while entirely failing to address what the case had actually revealed. Dr. Ambrose Kittredge's own private notes, a portion of which survive among papers donated by his descendants to a different regional archive entirely, and cross-referenced by the historian only some years after her initial article was published, offer a further uncomfortable layer to the household's carefully maintained explanation. Kittredge had served as the Bellamy family's physician for the better part of 2 decades, and his ledger's 7 recorded consultations of a private nature with Caroline Bellamy are accompanied, in his separate personal notebook, by a handful of terse clinical observations that make no mention of childbirth, confinement, or any condition consistent with the household's official account of her repeated seclusions. One entry, dated to a period roughly corresponding with Edward's supposed birth, reads only, "Mrs. B, in low spirits, complains of the quiet of the house, no fever, no other complaint of the body." A description the historian's article notes is difficult to reconcile with a woman recovering from childbirth, and easier to reconcile with a woman confined for reasons having nothing to do with her own health at all. Kittredge himself, so far as any surviving record shows, never publicly questioned the family's account, and the historian's article is careful to note that a country physician's continued livelihood in a community as small as that one depended substantially on his willingness to accept, or at least not to challenge, the explanations offered by his most prominent patients. It was this convenient explanation, reinforced by Kittredge's professional silence, by the minister's noted but unremarked observations, by the visiting cousin's letter that thought it odd, though of course said nothing, that allowed the household's arrangement to stand unexamined for nearly 2 decades. Jacob Pruitt, the overseer, testified on the first day of the hearing, before the matter of Ruth's relationship to the children had become the case's central concern, and his testimony, read afterward in light of what followed, takes on a different weight than it likely carried at the time it was given. Asked simply to confirm the property's boundary lines and the general management of its labor, Pruitt mentioned, almost in passing, that Mr. Bellamy had always been particular about who came and went from the house itself, more particular than most gentlemen I've worked for, and quicker to anger over a servant's loose tongue than over a bad harvest, a remark Whitfield did not pursue at the time, and won the docket records without further comment, but which the university historian's article cites as an early, unremarked signal of the very control over information that would later be exposed as central to the entire deception. The community's willingness to accept the Bellamy household's version of events, once established, proved durable even after the truth had been aired publicly in a courtroom. A local newspaper notice from the following spring, preserved on microfilm, reports the estate settlement in a single paragraph, noting only certain irregularities in the deceased's private papers without any mention of Ruth Elkins, Eliza Ward, or the substance of what those irregularities actually were. a discretion the historian's article attributes less to ignorance than to a community's practiced habit of not naming in print what everyone in the room that October had already heard named aloud. Margaret Bellamy did not remain in the county. Property records show that her portion of the estate was sold within 18 months of the ruling to a neighboring family, and county correspondence recovered from a private collection suggests she relocated to a relative's household in South Carolina, where she is not recorded as ever discussing the matter again. Edward Bellamy remained on the property for a further 6 years, according to tax records, before selling his own portion as well. In 1865, in the immediate aftermath of the war's end and the changed legal status it brought to every household in the county, including, of course, Ruth Elkins's own. What became of Edward afterward is not clearly documented. A single letter, undated, addressed to a cousin in Macon, references arrangements made for R.E.'s comfort in her later years. And though no further detail survives as to what those arrangements were or whether they were honoured, Ruth Elkins herself appears in the county's records one final time in an 1866 Freedmen's Registry, listing her occupation as seamstress and her residence as a small house on the edge of the town, no longer on the Bellamy property. The registry gives her age as approximately 50, though it notes, as many such registries did, that the figure was estimated rather than confirmed. No further official record of her exists in the county after that year. A family history compiled by her descendants, portions of which were shared with the university historian conducting research for the 1966 article, states that she lived for a number of years afterward, that she never spoke at length about the Bellamy household to anyone outside her immediate family, and that when she died, the family Bible she had once cared for in that house, and which she had apparently kept in her own possession after leaving it, was found to contain, written in a hand identified by family tradition as belonging to Caroline Bellamy, a single line added to the margin of a page otherwise recording only births and deaths. The line, according to the family's account, read, "She was the mother this house was afraid to name." The family history compiled by Ruth Elkins's descendants, a typed document assembled over several decades by successive generations and eventually shared in part with the historian, offers a somewhat fuller account of Ruth's remaining years than the county's own sparse registries allow. According to this account, Ruth continued her work as a seamstress in the town for close to 2 decades after the war, took in and helped raise at least one grandchild after the death of her own daughter in an outbreak of fever. The family history does not further specify, and was, by the account of a granddaughter interviewed by the historian in 1965, the sort of woman who kept her own counsel about the past, except once or twice a year, on a particular evening she never explained, when she would sit alone by the fire and hum something none of us ever recognized as a hymn or a work song, just a tune of her own, and would not be spoken to until she had finished. The same granddaughter recalled that Ruth kept a single photograph, taken sometime after the war by a traveling portrait photographer, showing her seated with 2 of her grandchildren, and that she referred to it. Without further explanation, the family ever pressed her to give, as the only family portrait I ever got to choose for myself. Whether Edward Bellamy's letter referencing arrangements made for R.E.'s comfort in her later years corresponds to any actual support Ruth received is a question the surviving record cannot settle. The family history compiled by her descendants makes no mention of any assistance from the Bellamy family after the war, and the historian's article notes this absence without drawing a firm conclusion from it, observing only that the silence of one record, in the face of the vague promise contained in another, is, in this case as in so many others touching on this family, more suggestive than conclusive. What can be documented is that Edward Bellamy, after selling his portion of the estate in 1865, relocated to Savannah, where a city directory from 1869 lists him as employed by a cotton brokerage, a considerably reduced position from the landholding status his family had once claimed in Lowndes County. He is not recorded as having married. A brief obituary notice, recovered from a Savannah newspaper archive and dated to the spring of 1881, describes him only as a native of Lowndes County, long a resident of this city, survived by no immediate family, a phrasing the historian's article calls quietly final, in the manner of a life that had, by its end, shed nearly everything it had once claimed to be built upon. One further exchange between Edward and Margaret survives indirectly through a note appended by Whitfield to his own case file, discovered decades later among a collection of the attorney's professional papers donated to a Savannah law library. Whitfield records, in a brief personal aside, clearly not intended for the formal record, that he witnessed the two siblings speak privately in the courthouse hallway on the final afternoon of the hearing, after Judge Calloway had retired to consider his ruling, but before it was delivered. Whitfield's note does not claim to have overheard the substance of the conversation in full, stating only that he stood at sufficient distance to grant them privacy. But he recorded two fragments, he says, carried clearly enough in the empty hallway to reach him. "Margaret," he wrote, said to her brother, "you have taken the only thing our father ever gave us, that no one could argue over," to which Edward is recorded as having replied, "He gave us nothing. She did. He only let us call it his." Whitfield's note ends there, with the observation, added in a noticeably different ink, as though appended some time later, that "I have represented families through worse disputes than land, but I do not know that I have represented one where the true inheritance in question was, all along, a person, and not a single acre of the ground we spent 3 days arguing over." Whether the two siblings ever spoke again after that afternoon is not recorded anywhere the historian's research was able to establish. What is recorded is that they did not, so far as any surviving letter or account suggests, ever again occupy the same household, the same town, or the same version of the family's history Margaret carried with her into her obscured later life in South Carolina, a version of events she never fully accepted, continuing, according to the single surviving letter to her Charleston aunt, to draw a distinction between what Ruth Elkins had done for her as a child and what she was owed for it as a matter of name or law. A distinction, the historian's article notes, the courts of the era were, in fairness, constructed specifically to permit her to draw, whatever its human cost. Edward, for his part, appears to have spent the remainder of his life in a kind of quiet, diminished exile from the family's former standing, a cotton broker's clerk in a city where, so far as the surviving record shows, no one he worked alongside ever learned the particulars of what had happened in a Lowndes County courtroom in the autumn of 1859, or what it had cost the woman he had, for one unguarded moment, allowed himself to name correctly in front of a room full of people who had spent 20 years teaching him not to. The historian who compiled the 1966 article, working from the recovered ledger, the partial court transcript, the Historical Society's donated papers and interviews conducted with several of Ruth Elkins's descendants, then still living in the region, concluded her piece by noting that the case had produced no clean resolution, legal or moral, and that this, more than any single document within it, was perhaps its most accurate reflection of the world it came from. The land was divided. The family's name survived, diminished. In the local newspapers of the following decade, as an example, as one 1960 editorial later put it, while reviewing the county's history for a centennial publication, of a respectability built, in this instance, quite literally on paper, that did not hold. Ruth Elkins received no formal accounting for the 20 years the household ledgers had once quietly recorded as maintenance expenses under her name. She received, in the end, only the acknowledgement spoken once in a courtroom by a grown man who had perhaps not fully understood in that moment everything the word would cost the people around him, or everything it would fail to give back to the one woman who had earned the right to hear it, and had waited 2 decades to hear it said where anyone else could hear it too. The county courthouse in Troupville was itself decommissioned not long after the county seat relocated to the newly established town of Valdosta in the early 1860s, and its records were transferred incompletely in stages over the following century, a process that accounts for much of what remains missing from this account and for the water damage that has rendered several passages of the original ledger illegible. The historian's own concluding note, appended to the 1966 article after its initial publication and included in a later reprint, states that she returned once more to the crossroads that had once been Troupville in the spring of 1968. This time not in search of documents, but simply, in her words, to stand again where the courthouse had been, now that I knew what had been said inside it. She wrote that she found the crossroads unchanged, the crepe myrtle at the old house site further overgrown, and a single new marker, placed by the County Historical Society at her own recommendation, noting only the general location of the former courthouse and the year of its decommissioning, without any reference to the case that had, however briefly, made it a place where a truth 2 decades buried had finally been spoken aloud, under oath, in a room built for the settling of debts and boundaries, and never by its design, for the settling of anything so difficult to measure as what one person owes another for 20 years of a mother's care given under a name that recorded her as property. What can be said with confidence, based on what survives, is only this: that a woman lived and worked inside a house for 2 decades, under a name that recorded her as property, that she raised 2 children who were not, in any sense, the household was permitted to speak of, entitled to call her what they, in fact, owed her, and that when the truth was finally allowed into a room built for the settling of debts and boundaries, it settled nothing so much as it exposed how much had never truly been settled at all. The house outside Troupville stood, according to a 1969 survey conducted ahead of a road-widening project, until sometime in the 1880s, when it was dismantled for lumber by a subsequent owner who left no record of what, if anything, he found inside its walls before it came down. No photograph of it is known to survive. Only the papers remain, scattered now across an archive, a historical society, and the private collections of a family that has never stopped remembering, even after the county itself largely forgot.